Hello and welcome everybody who is able to view this recording or joining us live. My name is Joseph Cordova. I'm an attorney with Florida Legal Services. I am the project manager of our Fair Housing project through HUD. It is an education and outreach initiative where we cover basically Orlando to Daytona Beach to St. Augustine, Placa, Gainesville, Gilchrist, Levy County, Dixie County, Ocala. We cover that whole north central region of the state of Florida. And we focus on fair housing and housing discrimination. We are what's considered our education and outreach grant. Our goal is to create awareness amongst everybody who's a part of the housing community. And if you think about it, that's everybody. So when we do these presentations, we like to identify certain target populations. We like to identify certain communities geographically within our region. Our goal throughout the year is to present as many of these presentations as possible to reach as many people as possible. And the importance tonight and the topic tonight is some updates in fair housing specific to LGBTQ plus community members. And with us this evening, I have Janet and Aldren, who I've been working with all semester, who really put this information together for us. So I'm going to pass it on to them, let them introduce themselves, and I'll let them take it away.
Hi, everybody. Thank you for coming tonight. I just want to introduce myself. My name is Janet Verwelius, and I'm a second-year law student at University of Florida.
And hello, everyone. My name is Aldren Collins. I'm also a second-year law student at the University of Florida. And I just want to say again, thank you so much to everyone who was able to attend tonight. So let's go ahead and get started. So we just want to begin, why are fair housing rights important? So, unfortunately, discrimination in housing is an ongoing problem, and it affects many classes of people, specifically including members of the LGBTQ plus community. In fact, there are many studies that show that there are issues in discrimination, and specifically a 2013 study by the U.S. Department of Housing and Urban Development, showed that same-sex couples experience significant levels of discrimination when responding to advertised rental housing. Additionally, the same study in 2013 found that heterosexual couples were favored over same-sex couples by about 16%. Furthermore, and according to another survey that was conducted in 2015, nearly 1/4 of transgender people reported housing discrimination because of their gender identity. This same survey also found that 1 in 5 transgender people in the United States have been discriminated against when seeking a home, and more than 1 in 10 have been evicted from their homes because of their gender identity. So discrimination in housing can take many different forms, and some may be more subtle than others. Examples of discriminatory statements in housing include some of the following. For example, sorry, we don't rent to families like yours, or this apartment isn't going to work for people like you. Sorry, only normal couples can rent here. This neighborhood probably isn't a right fit for you. And now just isn't a good time to be renting to people like you. So, phrases such as these are likely to be a violation of the Fair Housing Act. So what is the Fair Housing Act? It's basically a federal law that prohibits discrimination in housing related to transactions, because of race, color, religion, national origin, sex, disability, or familial status. There are 7 identified protected classes under the FHA, and the FHA protects these classes against disparate treatment, which is when a policy is discriminatory on its face, and disparate impact, when a policy is not discriminatory on its face, but results negatively on one protected class more than the other.
And we'll get a little bit further into disparate impact later on. So I just want to make sure we have a note of that. Having done this work for a little over a year now, that is one of the biggest areas that we have to investigate and uncover. So a lot of times when people have those red flags that go off in the back of their minds of saying, I don't know if this was discrimination or not. Well, sometimes it wasn't intentional discrimination, but it still may have resulted in, a disparate impact. So we'll get into that a little bit later.
So, where do housing protections apply? They can be applied in renting between lessor and lessee, in rental maintenance and rental policies, sales, real estate transactions, mortgages and lending, appraisals, homeowners insurance, and HOA policies.
And I like to jump in right here with just a quick little story. A lot of times when I present this information to new home buyers, a lot of individuals think, you know, we made it to the finish line. We don't have to worry about discrimination anymore because we're not tenants anymore. When the truth is that owning a home, you're still going to be susceptible to potential violations of the Fair Housing Act. The best example I have in recent news, I think this happened in the spring, and I want to say it was in Indiana, possibly Delaware. I don't know why I can confuse those two states, but there was a woman who went to sell her house. And she was having an appraisal done on her home. And she thought in her head, her home should be worth around 200 grand or something like that. Well, the first appraisal came back and it was about 150,000, 125,000. She said, this feels low. So she called a second appraisal, came back again at about 125,000. She still felt that she was being given a number that was extremely low compared to what she really thought it was worth. So the woman, the seller, she was a Black woman. And the appraisers had all been white men. So she called a third appraiser, but this time she got rid of all pictures, family photos in her home, anything that reflected that a Black woman lived there. And she had her friend who had a white husband. She had her friend's white husband come by and answer the door. He didn't say, I'm the homeowner. He didn't introduce himself as such. He simply answered the door, shook the hands of the appraiser, and let the appraiser do their job. When that third appraisal came back, it came back around $225,000 to $250,000. The home doubled in price simply because a Black woman did not answer the door. So when we talk about violations of fair housing, those little stories pop up all over the country, anywhere from being a tenant to a homeowner to trying to be a home seller. The Fair Housing Act still applies.
So, you know, who must follow the rules regarding Fair Housing Act? Basically, anybody from a landlord to real estate agents, lenders, insurance companies, and homeowners associations.
So I'm going to ask our audience. We have a wonderful audience today so far. I'm going to ask a little pop quiz here. What about fellow tenants? Do other tenants have to follow the rules of the Fair Housing Act? In relationship, can they be the ones who violate your rights under the Fair Housing Act if they're a tenant? Would anyone like to take a guess?
I would guess no, that these rules don't apply to them, but this is not my area of law. Inform me.
Okay, so it's not so much. Actually, I think no is the answer with a but, or it depends, as we all say in the field of law. It depends. So, if you are living in an apartment community and your fellow tenant is shouting racial insults or speaking ill of your family or anything related to your protected class, the landlord or the property management team, or if it's in an HOA, so neighbors, and then an HOA that oversees that neighborhood, they need to step in and they need to put an end to that discrimination, the taunts, the teasing, the assaults, verbal assaults, whatever it is that your fellow tenants and neighbors are using against you. The property management team needs to step in and they need to put an end to it. And if they simply pass and say, not my problem, this is between you guys, it's going to be the property management team that has now violated your fair housing rights. So while the action is going to result in a violation of the Fair Housing Act, the perpetrator is actually the property management team who was unable to successfully put an end to it. So it's one of those no, but kind of an answers.
So there are some exceptions as to who must abide by the FHA. The first one is known as the Mrs. Murphy Law, where owner-occupied buildings with no more than 4 units are exempt. So this applies when you're renting out a room in the home that you're currently living in. However, no one can advertise a preference. So for example, under the FHA, I can decide that I will rent my spare bedroom out only to another woman. However, I cannot advertise that my spare bedroom is only available to women. Another exception applies to landlords who own no more than 3 single-family homes. This is usually seen when someone has an investment property. But again, no one can discriminate in advertising for that property. The last exemption applies to communities that qualify for housing for older persons. They are allowed to exclude families with children under the age of 18. So this applies to communities that are registered as being for people over the age of 55. But the key there is that they actually have to be registered for that.
Yeah, and that's absolutely true. It can't just be a neighborhood where some families look around and say, you know what, we're a lot of empty nesters here and we want to keep it that way. So we're going to make sure that our neighbors don't sell their homes to families with children, or the, so-and-so down the street who rents out their house. We're going to make sure families with children don't rent there. That is a violation of the Fair Housing Act, unless you're a registered 55 and older community or something like that. So well said, Janet.
So as Aldren stated, there are 7 protected classes. The first one is race, which includes heritage, bloodline, and identity. Next is color, which includes your skin color and features. Disability includes any disability that affects major life activities. Sex we'll be discussing in more detail in just a second, but since a recent Supreme Court decision, sex now includes sexual orientation and gender identity. Sex also includes sexual harassment, hostile environment related to sexual harassment, and quid pro quo sexual favors. National origin includes either where you or your family's from. Religion includes faith, practice, and spirituality. It also includes the lack of practicing a religion. And lastly, families with children under the age of 18 are a protected class as well.
Real quick before we jump onto this next slide, I always like to make sure people know that you might be looking at this slide and saying, well, I don't know where I fit in. Well, you all fit into all of them. We're all members of every protected class. The idea is that whatever you are cannot be used against you. As you'll notice, Janet did not say what specific race is covered or what specific gender is covered or what specific religion is covered. All of whatever you are is covered. It's the idea that whatever you are cannot be used against you.
So Bostock v. Clayton County is a very important case regarding the definition of protected classes that was just decided in 2020. In Bostock, the Supreme Court analyzed exactly what sex-based discrimination encompassed. The court ruled that the term sex includes protections based on sexual orientation and gender identity. Although this case was actually about employment discrimination, the court's definition of what is included in sex-based discrimination applies to all laws that provide protections based on sex. Therefore, this case serves as the foundation to make discrimination based on sexual orientation and gender identity illegal in all areas of the law, including housing.
Yeah, and the legal reasoning behind this case, it's so simple, it really shouldn't have taken 200 years to get to. Basically, Supreme Court Justice Neil Gorsuch, who wrote the majority opinion, simply said, a man is fired from a job for loving another man, and a woman would be allowed to keep her job for loving that same man. That in itself is discrimination based on gender. You're allowing the woman to do something that you're not allowing the man to do. It's as simple as it gets, and it probably should have been the way we think about things dating back to the dawn of time. But we have it now, and because it happened in that employment-based case, the federal government sprinkled it through all the departments, and that's why it does have an impact on the Fair Housing Act.
It is important to note here, though, that protected status doesn't protect you from everything. Tenants and borrowers still need to abide by other housing rules and agreements. So for example, a family with children can still be evicted for not paying their rent. A transgender person can still be denied a home loan due to poor credit history. A person with a disability may not get all the modification requested if certain requests are not reasonable. However, families with children can't be evicted because they have children. Transgender people cannot be denied a home loan because they are transgender, and persons with disabilities can't be denied modifications because they have a disability.
Okay, so I'm going to take this slide here. So we talk about taking action under the Fair Housing Act. what's unique about the Fair Housing Act related to other areas of law is sometimes when you have, for example, an employment-based discrimination case, before you can take that to court, you have to exhaust all administrative remedies, meaning you have to file a claim with the Equal Opportunity Commission that oversees employment-based discrimination cases. The Fair Housing Act, that is not always the case. You can actually go straight to court if you'd like. You can file an administrative complaint if you'd like. You can also do both. At some point, you will have to choose one or the other, but I'll kind of explain what that means. So if you feel that you are the victim of fair housing violation, and I should have mentioned this at the beginning, the goal of this presentation is not to get everyone who's attending or viewing this session, it's not to memorize the Fair Housing Act, to memorize the protected classes, is to put those light bulbs and red flags in the back of your mind to say, you know what, that thing that happened to me, it didn't feel right. I wonder if I was being discriminated against. That's the goal of this conversation and this awareness, because we want people to understand that you do have a right to exercise what you feel might have been a protection that was violated. You have these protections and you have every right to maintain those protections. So if you feel you were violated as far as your fair housing rights are concerned, you can make an official complaint to the Department of Housing and Urban Development. It's a form that you can fill out online. You can also make a similar complaint at the state level to the Florida Commission on Human Relations. You can also make a complaint sometimes at a local level. So for example, in the state of Florida, we have 5 what are referred to as FAPs, Fair Housing Assistance Programs. I believe it's City of Orlando, I want to say Tampa, South Florida, Jacksonville, and I think the state of Florida makes up the 5th one. And I'm sorry if I have that wrong. But the idea is that depending on where you live, you might be able to file directly to a local office that can do the enforcement and the investigation. There are also some counties in the state of Florida, for example, Alachua County, that is not necessarily a HUD grantee recognized as a FAP, but it does have its own Office of Equal Opportunity that oversees its own fair housing ordinance. So depending on where you live, it might affect or impact where you send your administrative complaint. But that's where I come in, okay? My organization, we help you navigate the system for this administrative complaint. We can help you write it. We can help you do the pre-investigation. We really try our best to do all the legwork we can to make sure that when you submit that complaint is going to satisfy questions of jurisdiction, standing, timeliness, and everything else that goes into making sure that the complaint that gets sent off has a really good chance of resulting in some sort of remedy, whether that remedy is for you or it's on behalf of the community because so-and-so is no longer allowed to pursue or practices that are discriminating. So contacting a legal aid or legal services organization such as myself. And like I said before, you are always welcome to contact a private law firm and just move forward with legal action. And as I did say before, you could do both at the same time. But once your administrative complaint reaches the hearing state, so you're now actually going to be in front of a judge, you do have to make a decision whether or not you want to pursue that administrative complaint or you want to pull it back and continue with your private lawsuit. The reason is because you cannot have 2 cases of the same incident in 2 different courts at the same time. So that's what taking action looks like. And one thing I always like to tell community members, and I briefly mentioned this, a lot of times when you do fair housing complaints, by the time the investigation is complete and some sort of remedy is coming your way, a lot of times time has passed by. It could be a year, it could be a year and a half down the road. You've moved on, you're living into a different apartment, you've bought a new home. But one thing that the Fair Housing Act is really good at doing is it's making sure that those who are violating your rights and protections don't do it again. So I often tell clients and community members that while you might not feel that you're going to get much out of it, your community will. The community you leave behind is going to get a lot out of it. You can consider yourself a fair housing hero because you're the one that stood up and said, I'm not going to let this happen anymore, not necessarily to me or to future generations that live in this apartment community or have to put up with these abuses of this particular landlord. So taking action is very important, and that's what I'm here to help you do. Okay, and did you guys, I forgot, I take this slide as well, right? Okay, so one of the things that Aldren and Janet did exclusively extremely well this semester, and I got a chance to review a lot of their work, is looking at community research and awareness as far as saying, so now that the Bostock decision has updated the rules as far as what is a protected class underneath the realm of sex and gender, it now includes sexual orientation and gender identity. The question is, should local ordinances, state statutes, should they include this new language? Or is it enough that whether you include the language or not, it's protected? So for example, Alachua County's Fair Housing Ordinance reads, "It is a matter of concern to the board to protect and safeguard the right and opportunity of all individuals to be free from discrimination, including discrimination based on race, color, national origin, religion, sex, marital status, age, disability, sexual orientation, gender identity, or expression." Alachua County already has those words written into it. So if I'm an individual who feels that my rights have been violated and I am pursuing information about my rights, I am pursuing an understanding of whether or not my rights have been violated, and I go to the Alachua County Fair Housing Ordinance, I can read for myself that I have those protections. If I live somewhere else that doesn't actually have it written out, do I know that I've been protected because the word sex includes sexual orientation and gender identity? And that's an interesting question that we came to, that we wanted to bring to the community to kind of get an idea of where our efforts are going to be better spent. So for example, in our project region, only 3 out of the 12 counties that were researched actually include language that specifically says sexual orientation and gender identity is protected. The other 9 local counties haven't made any updates, but they might not think they have to, because the word sex already includes sexual orientation and gender identity. So we're going to open it up to questions and answers, but keep in mind that last piece, that's our question back to the community. So we want to know from the community, what's more important, telling the masses that sex includes sexual orientation and gender identity, or getting the counties to update their language? So at this time, whatever questions you have, ideas, thoughts, the floor is open.
Hey, so this is Simone again, shocking. I'm intimately familiar with Bostock and how it applies to the areas of law that I do, but I wasn't super familiar with how it's been applied thus far in terms of, case law to the Fair Housing Act. And my understanding was that the FHA doesn't directly rely on Title VII. So has there been case law applying the analysis the Supreme Court made in Bostock to the FHA?
I think case law is like happening as we speak, because the case happened last summer. It wasn't until February that the Biden administration put forth the Warden memo that said from this point forward, the FHA will be enforced in a way that says sexual orientation and gender identity is included underneath the protected class of sex. So you're right, the Fair Housing Act itself was not changed by Congress. It's simply being enforced to include the legal reasoning behind the Bostock case. So for fair housing, we're now looking at, 9 months of enforcement. So I actually don't know where the case law stands on it yet, probably because there's only been 1 or 2 that have actually even made it to an appeals court or something like that. So great question, and we might have an answer soon.
Gotcha.
Yeah.
Thank you.
Yeah.
I had one other question. So we work a lot with the intersection of individuals who are LGBTQ, and particularly transgender folks, and individuals experiencing homelessness, which, as you can imagine, there's a lot of intersection there. So we do trainings for housing and homeless shelter providers on the equal access rule. And I know, under the previous 2 administrations, there was the 2016 and 2012 equal access rules that made very clear that trans folks can't be, denied protections. And then there was another rule that was proposed that would allow discrimination against trans folks. How does that fit into this, and where does that all stand?
Before I jump in, Janet, Aldren, you guys researched a little bit of this. Do you just want to talk a little bit about what you found, even if it doesn't explain the law behind it, just kind of what you found with boots on the ground kind of a thing?
Sure thing. So I can speak about that just briefly. So we actually looked up several different homeless shelters in the 12 counties that our kind of our domain. And we actually found that none of them explicitly say that sexual orientation and gender identity are protected to the public. There's nowhere that that's publicly stated. And in fact, we attempted to contact several of the homeless shelters in the area, and only one person responded to us. And in fact, he even admitted to us that the only policy that they have per se regarding anti-discrimination is in their employee policies. So basically, it's their policies are known to their employees that their employees can't discriminate, but nowhere is it explicitly stated to the public that they can't discriminate. So I mean, that's definitely, I think, a challenge to the wider public that's facing a homeless issue that they might encounter.
Gotcha. Thank you.
And I'll jump in further. So I think the more liberal understanding and interpretation of where fair housing rights land is that key phrase that says housing transactions. So what's included in a housing transaction? Or we had that slide that talked about appraisals, selling a home, renting a home. Well, if you're seeking refuge in like a DV shelter or just simply a general homeless shelter because you are homeless, if you plan on using that shelter as housing, we in the fair housing community say that's housing. Where it gets a little gray is in like transient housing. So like hotels, motels for tourism is not covered for fair housing. But if you're using that hotel as your home and you consider it housing, it's back to being covered. So I think the strongest approach is to say homeless shelters count as housing, and therefore any denial of shelter is a denial of housing under the realm of housing transactions. So in our research with Janet, Aldren, and myself, we came across like law blogs and all that kind of stuff, where there are definitely some legal opinions that say it is absolutely a part of homeless shelters. And I tend to believe every word of that legal reasoning. So, which is one of the reasons why we went down the road of do your homeless shelters identify publicly this particular protection? Because if you're going to turn people away or not let them know that they're protected, you're the last stop between homelessness and the real dirty impacts of homelessness and literally not having a roof over your head. So to me, that's housing.
Gotcha. Thank you.
Yeah. Other questions? I know we had someone log in there towards the end. I don't know if you have any questions or anything you might want us to repeat.
So I have a question about the presentation itself, Joe. Is your plan to use this presentation going forward past this point with what kinds of stakeholders?
Great question. So as you know, we are recording this evening because we wanted to have a recording of the presentation itself for future audiences who weren't able to join us. But my work is education and outreach. So I'll be delivering this presentation along with presentations that focus on other target communities, geographical, cultural communities, you name it, we're gonna reach that community. So last year alone, I think I delivered 54 live presentations via Zoom / in person. So having recordings like this help us so that people can view it at all hours of the day. But I'm always looking for opportunities to deliver similar presentations because I really enjoy the community discussion side of it. That's where a lot of the great questions come from, a lot of good answers. It forces me to go do some research and stuff like that. So this presentation, it has a home. It will have a home on our YouTube channel, and it will also kind of be the catalyst for future presentations similar to it.
A follow-up question to that is that the Fair Housing Act, of course, provides for attorney's fees, right?
Yes, I believe so. That's
so if people choose to pursue legal action privately and are not, don't feel like they can afford that, that's something you want to bring up with people, right?
Yeah, I'm glad you brought that up. I come from the perspective of legal services. So right. Our work is grant funded. And it's only when we've satisfied all the, the expectations of the grant that we might consider the opportunity to move forward with something, outside of the grant. But that's not really something that I'm thinking about very often. But you're absolutely right. If you go to a private attorney, that attorney has an incentive to take your case because attorney's fees are available. And one thing I told Janet and Aldren, and I hope you guys did this, I said, go down the rabbit hole of case law and fair housing. When you go down the rabbit hole, you start to uncover these cases where these damages, they get really high, hundreds of thousands, the low millions. If you're getting attorney's fees based on that number, it's definitely worth your while to take that case. And as I mentioned, when I do these presentations, my audience is, everybody who might be susceptible to fair housing violations. We also do a lot of work with community advocates and legal aid attorneys. And this last summer, we did like a summer lunch bunch where we did 10 presentations on Thursdays at noon. We had a different topic each time. By the end of the summer, the majority of attendees were attorneys. So I'm glad you brought that up because you definitely don't want, like you said, my inability to pay for representation to stand in the way of exercising these rights. So I'm glad you brought that up.
Oh, I also think that private attorneys would be interested in the information, especially since the Bostock case, that they may not know of the kind of added protection that case could bring them.
Yeah,
I think you'd like to think that private attorneys are all savvy about that already, but it might be, new attorneys might not know that they can bring a case like that.
Well, and you're absolutely right. And one of the reasons why it's gonna be, a good time to take those cases is, like we were saying, you're gonna have a lot of counties that are not enforcing their own laws because they also don't know it's the law. And so you're going to have to go to a private attorney that needs to know this is now protected. So you're kind of a pioneer in this area of saying not only were your rights violated by this landlord, but the county also needs to step in and enforce their own laws wherever they can. So it's like new information for everybody. And the more we can get attorneys on board, the better. Yeah.
I had one other question. So,
please.
And I am kind of grappling with this a bit in other areas of trans rights law, but the current administration has put out a lot of really helpful guidance applying Bostock and other things to other areas of law outside of Title IX. And what can we be doing to ensure that those things remain in place even if there's a change in administration, because these aren't Supreme Court decisions, they aren't legislative actions, they aren't, from my understanding, they could be changed. So how can we ensure that these protections remain regardless of, executive administration?
My answer would be, and I would love to hear from everyone else on this, my answer would be kind of what Professor Flox, you were getting at, is the more we can get attorneys on board to take these cases, the more we can build a foundation of case law that identifies this as the norm. This is the practice. This is what we do. Go ahead and appeal it because we need a court opinion. Go ahead and appeal it again because we want a stronger opinion. But the more we can basically plant these roots of this protection, I think it's going to be harder for another administration to come along and outmaneuver case law simply by trying to change enforcement of a rule.
Right.
That's my take. What do you think?
No, I think that's great. I also think that, like you were saying earlier, getting counties to adopt specific language that not only enumerates sex as a protected characteristic, but also, gender identity and sexual orientation, they're not going to go back. Many counties won't go back and undo that just because they may be allowed to in the future. And I think getting those protections in place on the countywide, statewide, whatever level we can, ensures continuity of those protections. So I think that's a great idea.
Yeah, I think you're right. What we've seen is, it's not a rule, but it's kind of a unwritten rule. Once the government giveth, it shall not taketh away. Right. So like you said, once it's written in there, it may not be written in stone, but it's much harder to take away a protection than it is to offer one. So yeah, I think you're right.
The counties that had that language in their ordinances already, did they have that language in there before Bostock or after? before?
Yeah, from my understanding, it was before. Janet, Aldren, did you guys come across anything differently, or did you see anything that might have had a recent date on there?
So, in everything that we found, nothing explicitly stated when that language was added to the 3 counties that did have it. However, there were a few counties that had the list of protected classes, and there was no mention of sexual orientation or gender identity. But below the listed classes, there was like a little blurb, like per HUD regulations, we now have to include gender identity and sexual orientation. It was almost like its own separate thing, which was a little bit strange. But so there were a few counties, I want to say probably, about 5 or 6, that did acknowledge the HUD update and did, say that this has been included later on and was not original to the language.
And I think exactly what you just said, where we also saw that was in like public housing authority implementation enforcement. There was what year was it? 2000. It was in Obama, 2011, I want to say. There was a similar update specific to public housing. But exactly what Aldren just said, it was like they reluctantly put information, by rule, we have to tell you this. It's not our rule, but it's a rule we have to tell you about. So it'd be nice to clean up that language.
Yeah.
Yeah. And no surprise, the areas that already have that language is going to be Alachua County, Orange County, and I want to say it wasn't St. Johns County, but I think it was the city of St. Augustine. Is that right?
Yes, and I remember it specifically too, the like you mentioned, Joseph, the housing authorities, they would often include the little extra blurb about, per HUD regulations, we now have to include this. But I do remember St. Johns County Public Housing was one that included that.
Yeah. So, our quest is, how much do we spin our wheels trying to get, small rural counties to update their language? I think it's still worth it. I think that's an effort that is valiant and needs to be done. But at the same time, we need to balance it with just telling people, whether your county says it or not, it's still protected.
I think that I think that they're not necessarily mutually exclusive. Right. And then if you keep informing people, there can be a lot of pressure on those smaller municipalities to change the language. I mean, that's one way to go about it, is by educating enough people so that they'll put the pressure on their county. So
yeah, I think you're exactly right. You said it. That's definitely something we need to do. I like that.
But if you can also educate the counties and they see the writing on the wall, then there's that too. I think both. The answer is both, Joseph.
Yeah. Yeah. Well, and one of the things we've seen, and Janet and Aldren talked about this, and I'm guessing this is true across the country, and it's definitely regional, but counties are often competitive with nearby counties. And when one county has it, the other county feels we either need to catch up, or we're stubborn and we're proud that we don't have it. But there are counties that have relationships with each other, and sometimes you have to feed off of that. So if you're Alachua County and you're this, oasis of a county that offers this language, and no other county anywhere near you has it, I think you're right. Eventually, residents of other counties are going to say, well, why do they have it and we don't? And that kind of creates that friction between counties. And before you know it, maybe one of them tips, or maybe 2 of them on the other side say, we'll do it too. So it's like a living, competition between counties, and you never know what's going to be the one that kind of rubs them the wrong way.
Except that sometimes I think Alachua County is a little bip more progressive than the surrounding counties, and it may be the opposite. It may be that the other surrounding counties are like, we don't want to go there.
Yeah, whatever Alachua is doing, we're not doing that. Yeah, I think you're right. Definitely. Well, what other questions do we have? Any thoughts? Any other concerns? Well, it's 7:46. I guess we can let everyone have their evenings back, unless there's anything else anyone wants to say. Janet, Aldren, do you have any other final thoughts?
I would just like to thank everyone for coming again.
Definitely. Well, okay, so thank you to our audience for helping us create a lively community discussion. I really thank you because the recordings do go a long way. We keep track of those views and those hits, and when the numbers go up, that's one more person that got to hear this conversation and be a part of it and be a part of this movement. So I really appreciate your attendance, your participation, and with that, I guess we'll say goodbye and enjoy your evening. Thank you.
Thank you. Great job, you guys.
Yes.
Have a good one.
You too.